Doc from Barcast Audio here today to talk with you about the Uniform Bar Exam, the Multistate Bar Exam, and more importantly, contracts law questions on the MBE, how you can improve your scoring. And we're going to be covering the first and, to my mind, the most important subject that is covered on the MBE, contract formation. We're going to be talking about some of the basic principles you can use to score better on those questions. Let's jump right into it. Begin on the MBE, the Multi-State Bar Exam, the multiple choice questions. You can expect 6 to 7 contract formation questions just right off the bat. Now, if you're preparing for the bar exam, if you went to law school, you're probably already familiar with this idea of offer, acceptance, consideration, sort of the core tenets of contract formation. But you're probably also familiar with the defenses to formation, all that kind of stuff. And we're going to just run through what the most important principles are in this short video for the MBE. When it comes to contract formation questions on the MBE, there are really just 2 skills you need to develop and get really strong at. The first skill you need to develop is that you need to be able to readily distinguish between common law and UCC contracts and contract formation of the two, and the different rules regarding formation that apply to both UCC contracts for the sale of goods and common law contracts for services and all other contracts. The second skill you really need to get strong at here is you need to understand when a contract is formed. By understanding when the contract is formed, this timing element is going to be key and central to getting these formation questions right, because a lot of them are sort of aimed at when the actual contract was formed, when an offer was accepted, when an offer was rejected. That is going to be central to your development with these MBE questions. Let's dig into the first of these 2 ideas, distinguishing between UCC contracts and common law contracts. As you probably know by now, the UCC covers sale of goods contracts, while the common law covers all other contracts, including services contracts. Mostly that's what we're going to be talking about on the bar exam, but we also cover some real estate contracts as well. But it's also important to remember that each of these contracts has different rules for formation. For example, at common law, they apply the mirror image rule holds that an acceptance must mirror an offer in order to be adequately accepted. If an acceptance does not mirror that offer, if it changes the terms in any way, that is a rejection of the initial offer. So a contract is not formed at that time. Any additional terms, any different language in an offer will serve as a rejection because it does not mirror the image of the offer initially sent. So you can't accept by changing the terms of the initial offer. That just does not work at common law. By contrast, under the UCC, the mirror image rule does not apply. Under the UCC, specifically UCC 2-207, additional terms can be added to a contract and still tacitly accepted by the parties. Generally, under UCC 2-207, additional terms will still allow for the acceptance for the formation of a valid contract between 2 parties, but whether those terms are actually going to be validly accepted or added to the contract, that is going to be a question that depends on a number of other factors. This idea is generally referred to as the battle of the forms at the UCC. And remember, once again, that at common law, if I sent you a contract and you wanted to make some changes to the terms and you sent me back that contract, then you would be sending a counteroffer and rejecting my initial offer. Whereas if we were both vendors selling something for the sale of goods, that would be an entirely different situation. We would have this battle of the forms situation where that contract that you sent back to me would not necessarily serve as a counteroffer, as a rejection. We could still accept that agreement, and we would figure out under the UCC what terms that you sent back to me would be included, which ones would not be included. So I mentioned that under the UCC, whether these additional terms actually become a part of the contract depends on a number of factors. Let's just run through those factors very quickly. The first of these factors are whether the terms are actually different from the ones that were sent. Second, whether the parties involved are merchants is going to matter. And third, whether the terms that are sent are truly additional. That is going to be the third sort of consideration as to whether these terms are ultimately put into the contract and accepted as part of that underlying agreement. So we've covered sort of these distinctions between the UCC and the common law and why those are important in assessing these formation questions. Now let's talk about that second skill that I spoke with you about, determining when a contract is formed. So for the most part, contracts questions on the MBE are going to give you a short fact pattern summarizing a contractual interaction between 2 parties. Now, from that short factual interaction, you are going to need to identify the following 5 things. First, you're going to have to identify what constitutes an offer. Next, you're going to have to identify what constitutes a rejection. Third, you're going to have to identify whether there's been a revocation of the offer. Fourth, you're going to have to identify whether there's been a counteroffer. And fifth, you're going to have to identify whether the offer was accepted, and if it was accepted, when that acceptance took place. So these sort of 5 questions, you're going to have to just off the bat identify in every question. And if you start to get good at answering those 5 questions, at looking at a set of facts, looking at an MBE question, and answering those 5 questions relatively quickly, you're going to see your MBE scores on these contract formation questions go way, way up. And as I said before, these are going to be 6 or 7 questions on the bar exam. So if you can get 6 of 7 or 7 of 7 or 6 of 6, that is an incredible start to your bar exam, to your MBE, to your path to passing this exam. So treat it very seriously. Try as best you can to develop these skills as you're going through these questions, and you will start to see your scores in this area improve immediately. This concludes our video on the first section of how to improve your MBE score for contracts questions. We covered formation in this video. Be sure to check us out at barcastaudio.com. Be sure to subscribe to our channel for more of these videos. Share with your friends if they're taking the bar exam, if they're in law school, whatever they're doing. We have lots of helpful content here and at barcastaudio.com. We have audio outlines, essay attack sheets, everything you could possibly need to pass the bar exam. Until next time, I'll talk to you guys soon. Bye now.